Okay. Good morning. Good morning, Michael. Can you hear me?
I can.
Awesome. Good morning, everyone. Good morning, Michael. I can see that our attendees are already up and on. So thanks everyone for first of all taking out time to to join us in this session with Michael. And Michael, thank you very much for taking our time to speak to people from all over the world, especially talents from emerging markets and from Nigeria about what we're doing. So thanks
Sure,
a lot.
my pleasure.
Yeah. As we get started, we will, do a bit of introduction about what we do at Agora. This is going to be an hour session. The goal is to answer as many questions as possible. The good thing is that as people started registering when we announced this a couple of weeks ago, there has been a lot of questions submitted. And so what our team has done is to mine through those questions and take similar questions and, bring out the best that those that we can answer live on this session. So I'll do a bit of introduction about what we do at Agora and a bit of introduction about myself. My name is Oluyomi Ojo. I'm a partner at Agora. We started Agora to help talent from emerging markets figure out immigration processes and get more clarity around the process, and most importantly, be able to, go through the rigorous process of immigrating into the United States via the O1, the EB1, and the EB2 NIW visas at the moment. So, again, how do we do this? The first thing for us is we realized when we started Agora that the most important thing to help people is to have deep expertise about the industry. The next thing is good use of technology and the ability to back the talent with adequate stories and being able to represent everyone in the best way, and most importantly, work with the right attorneys and the right players in the sector. For us, three things are very important: the story, the strategy, and the structure in the candidate's application. We always say this clearly: we are not a law firm. We are more of a technology company, but within our network is the entire process and the attorneys that will take care of the petitions for our clients. And why does this matter? If you look at data over the past couple of years, there are over 700 unicorns founded in the United States. That, by the way, is more than 60% of global unicorns. And these companies were founded by immigrants or co-founded by immigrants. At least most of these companies were founded by immigrants and co-founded by immigrants. And if you look at those immigrants, these were like hot talent, great talents who moved to the United States within the last 2 decades, whether they moved in as an entrepreneur or they moved in via the H-1B visas. If you look at every one of them, they all came in through talent and educational pathways. And so we started asking ourselves, what if we could open this same channel and this opportunity to talents from Africa? What will the next one decade looks like? And this is exactly how Agora was born. What kind of visas do we offer? We offer the O1 visa support, which is for people with extraordinary ability in business, technology, art, science, sports, creative industries. The O1 visa is a work visa, 3 years, valid for 3 years, renewable. And then we also support the EB1 visas and the EB2 NIW visas. Both are green cards. This is what people have to say about us. But this conversation is less about Agora, but more about the questions that you guys have and the answers that you'll be able to get on this call. So I met Michael via the industry, and he's been super helpful, in terms of supporting the team, even supporting everybody across the immigration sector. A bit about Michael. Michael is one of the top veterans in this space. He's been at the USCIS, working on the government side for over 2 decades, 28 years to be specific, until May. Before Michael left the USCIS, he's done a lot of amazing work, had over 10,000 employees reporting to him. He was managing multiple field offices, 89 field offices across the USCIS operations. He was one of the people that designed the EB5 program. But now Michael runs True North Pathways, which is a firm that supports practitioners across the industry. So if you really want answers, you want to get answers from someone who has been on the other side, both on policy making, on cases review, I mean, the person who knows the black and white and the whole 9 yard of immigration. It's someone like Michael. So Michael, it's amazing to have you here. And we can just dive in quickly. But before I dive in, do you want any word from you before we dive into the questions?
Just to say thank you for having me. I really look forward to the question and answer time. I've experienced since retiring that the level of transparency and awareness of how USCIS works, how some of these decisions, whether it's O1 or EB1 or EB2, are made is such unknown knowledge. So I look forward to sharing it with you all and the guests on this call. So awesome. Let's have some fun.
Awesome. We'll jump in with the first question. And so the questions are anonymous. We did not put the names of the people who asked those questions, but these were like pre-vetted questions from people who registered for the event. So the first question, right? Given the current trend, I mean, I guess this person is referring to what's going on with immigration today. What policy or operational changes do you foresee at the USCIS that could significantly impact international students and skilled workers over the next couple of years? How should those who intend to file or petition soon prepare?
Yeah, this is a great question, and we could probably speak for the balance of the hour on everything that's in here. But to go faster than that, I would answer the question by saying, first of all, great question. Second, this administration came to office last January and immediately made their intentions known, and since then have been working on the issues that you point out in the question, right? So there is already some changes to the F1 category for foreign students. No longer is it duration of stay, but it is a fixed period of admission, which isn't fatal. It's just more bureaucracy, more paperwork. But the traditional pathway of F1 to OPT to H1B to EB1 or EB2 that so many of the folks that you described at the start, all those founders and others have taken, has really been the focus of this administration. And each part of that pathway has come under, has seen some changes or will see some changes. So the question is absolutely right. I think if you're planning to be, or if you are a student right now and you're looking to use your OPT on graduation, you should be very careful to watch. The government has announced its intentions to limit or eliminate the OPT benefits for some students. They haven't said how, so it's good to watch that. As with so many of the things we talk about, if you're looking to access these now or in the next few years, my advice has been get it while you can, because they have not made the changes yet, but they're about to make the changes. And the same with EB1 and EB2. They've announced their intentions to change the rules. Everyone assumes, and I think it goes with everything else they've done, to make the requirements a little tougher. So what does that mean? How should those who intend to file or petition prepare? My guess is for the EB1 and the EB2, when you file your petition, the general rules, the general concepts, the general things that you just described a minute ago won't change. It's just the bars that you have to reach will get higher, right? So if for those of you who have already looked into this, for EB1A, you need to show 3 out of 10 criteria, and then you need to show how that impacts the nation in the final merits review. They could make it 5, or they could make it much more difficult to make those 3, and they could take a more narrow view on the final merits review. Yeah. So it doesn't mean that you should give up. It just means the bar might be higher, right? And so the question, again, back to the actual question, how should you prepare is, have a plan. You'll probably hear me say this several times today. Yeah. Some of the 700 unicorns were just self-evident, right? You just walk in the door and they invented, Google or they did whatever, but others, most not. And they're the result of planning. They're the result of thinking. I think one of the slides earlier said story. They're the result of thinking of the story that you're going to show to the USCIS to say, I am special and here's how. So it's It's be aware of the changes and then plan to meet them. So I think that's my long-winded answer to the first question.
To that question, one of the things that we started doing at Agora is pretty much pushing our clients and enforcing higher standards. So like we say things like, you've got to think of yourself as the USCIS officer and just keep asking yourself that, is this enough? Like, I need to hold myself to a higher standard when I'm petitioning, like nothing on the surface. I need to go super deep in the level of evidence that I provide and the proof that I am actually who I say I am. So the next question is, from your experience inside the USCIS, what are the biggest differentiators you see in successful petitions for talent-based visas, O1, EB1, EB1A, and the EB2 NIW, and what common mistakes should applicants avoid?
Yeah, so great. Again, another great question. The good news, this goes for probably many of these questions, right? If you're on this call, I think that you're not starting at zero, right? You're already halfway or some part of the way on your journey, right? You've already started accomplishing things. You've already started making your way. And that's good, right? You need to recognize that. Probably if you're on this call, though, you hadn't started out by studying immigration and knowing immigration law. So there are folks that can help you put those two pieces together. And that's why I get to the answer to this question, sort of conceptually, and then I'll maybe get a little more specific. The biggest differentiator is really how people present themselves, right? You can have I've seen two very similar cases when you look at resume, when you look at accomplishments, when you look at longevity, even awards, and one is written like a story that hits the requirements and says, Valverde started out as an intern and soon, whatever, and showed the arc of accomplishment. And another one seemed to, the other one I'm contrasting seemed to just assume that the USCIS adjudicator would recognize their greatness.
Gotcha.
And what I would say on those, bad on USCIS for not recognizing the greatness, right? If the qualifications are the same. But, what you said earlier about putting yourself in the shoes of USCIS, they have to look through applications every day from all sorts of industry, from all sorts of people in technology. If you just look at how people are working in AI, there's so many different kinds of AI. And before that, the cloud. And it's hard to expect those people to be experts and to be able to sift out which words on a resume, which words in a letter are the really important ones. And if you don't take them by the hand and walk them through it, you're really doing yourself a disservice, even if you're the greatest inventor ever. And then maybe to get a little more specific, if necessary, some of the, common mistakes, I think, you have to know your own record. You have to know where you are. You have to get some help. A common mistake is I think people are just, sometimes they wait too long. They think they need to really be getting that next award or getting that other thing. They really need to get 7 out of the 10 criteria for EB1A. And then otherwise, sometimes people show up too early and they're probably a year or two away from being able to write or have written about them a really great application. So I don't know if that's specific enough, but I think that is generally where you see the denials. There's a flavor of people who just maybe aren't what the regulations call for, but right. There's a flavor of people where if you've done the work long enough, you can see that they are just, a little bit away. Their career arc is here and you want it to be up there. And you can see that they're getting there and maybe they're ambitious and they're applying and they'll apply a year from now or 2 years from now and they'll get it. But that's one of the common mistakes that I see.
Yeah. I mean, to add to that, one of the things we tell people to do is if you're asking questions, if you're getting on calls like this, if you're going on the USCIS website to make research, if you're going into Google or ChatGPT, you're already above a lot of people. And if you're going to file in the next 2 years, right, then you have to start talking to people now. Now, this doesn't mean that you're just starting to build your profile or you build your experience and all of that. It simply means that you've done that before now, but you intend to file in the next 2 years. The best time to start talking to people, to start preparing, to start putting things together is now, not 2 years down the line. So you're right. You're very, 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 very right. Next question is okay. This is very good. How can I write a convincing O1 or EB1A application how can one write a convincing O1 or EB1A application when you've not had a conventional career path? For example, you've worked 9 to 5 all your life. For instance, I work as a marketer in tech. What are my chances when I'm not a founder or an entrepreneur?
That's a great question. The first thing is don't talk yourself out of something you haven't put in for. So I'm glad you asked the question. Yeah. I'm glad you're here. The second is, that's not an uncommon, I'll say it differently. The common pathway that you hear, right, is someone who has their master's degree or comes through university, gets the H-1B and moves into the EB-1A through that career. That is the pathway that is most advertised on all the services that I've scanned over the years. But it isn't. So there's that. It's not uncommon though for those individuals who have the resume, who have the accomplishments, to not come through that path. Right. Again, you have to think about it as a story. There is no requirement, EB1A, B, and C might have other requirements for university degrees and other accomplishments, but in EB1A, you can show your qualifications without going through the academic route. Is it as common or easier than others? Probably not. But again, I think I'm going to say the same thing, at least for the first 3 questions. If you have a plan and you have a story and you have the accomplishments to back it up, how you get there doesn't matter. It's a very results-based package that you put together and submit to the USCIS. And then when you get your petition approved, when you talk to the consular office, if that's your route, you're just going to have to tell that story and show why you've made the difference in the part of the market, in market or in tech. How did you change the field? How did you, what did you win? What was your salary? Doesn't matter if that salary was based on, a primary school degree or a PhD. If the salary is high enough, that's the bar. So, don't talk yourself out of it. But again, it's just focus on the story, focus on your resume and the accomplishments that you did.
Thank you. Just to kind of add to that, we've seen on our side clients who have never built a business before, but the level of work that they've done in the businesses that they work with, they check those boxes, right? They've built products, innovated within those companies, and those things were valid even to the high standard criteria like the original contribution in the field, even though they haven't built their own thing. So there is no limitation that you must be an entrepreneur or a founder, even though the founder and entrepreneur pathway seems to make it a bit easier, but there is no rule that says that you've got to be that kind of a person. The next question: how best do we frame or represent a non-traditional background without triggering RFE? Now, this is very similar to the first question that we just read, but this person is pretty much saying how best can they position their petition without triggering RFE.
Yeah.
And maybe you want to also address the case where while answering this, people tend to fear RFEs a lot. Maybe you want to sort of share more about that myth. Yeah.
Yes, absolutely. That's what I was thinking too. So great. So the answer I would give to question 4 is very similar to 3, right? You just need to focus on your story and how it shows that you hit 3 criteria or 4 or however many you choose to make, again, I keep talking about the EB1A, but in the O context or the national interest waiver, how you hit the bars that you need to hit, right? There's no requirement that you get there a specific way if you can meet the requirements, right? So it's, now I've said it 4 questions in a row. It's how you tell your story. And again, if you're on this call, you're probably, partial or maybe all the way through building a career, having accomplishments that gets you there. But the question is great because it does acknowledge that, like most of us, we're not founders. Like most of us, we have worked for people more often than we've worked for ourselves. And how do we do that? So I'll be blunt. I guess it is harder to convince an officer without having that sort of level of accomplishment. That's the wrong way to say it, but it's possible, right? It's you just frame your accomplishments in a way that, again, shows that you meet the criteria. If you do get approved right away and don't get a request for evidence, that's great. If you do get a request for evidence, and I was just looking at one yesterday, well, I'll stop and say there are requests for evidence, and then there's requests for evidence, and it's a spectrum, right? And on this end of the spectrum, there's the request for evidence where it appears that the officer just hasn't even seen your case. They just ask you for everything that you've already submitted, and then
we have seen a lot of that recently.
You have to take a breath and be patient, and then maybe respectfully say, hey, I've sent this or whatever. But on the other end of the spectrum, there is the request for evidence from the officer who's looked at everything and said, hey, you've met this criteria, you've not met these other criteria. But often in that second part, you'll have a roadmap to how you make it, right? For example, the one I was looking at yesterday was about, it had two criteria not met. One was scholarly publications, and one was judging the work of others. And on the judging work of others, it was, hey, I saw that you sent a contract to be a judge or be a reviewer in this journal, but we don't see the results that you've actually done it, right? Yeah. And you kind of want to roll your eyes a little bit, but that's a roadmap to say, oh, okay, well, let me show you. In that case, I think they did on first route, but they resent it and said, we'll show you here's where I edited this prestigious journal, or here's where, I had this scholarly publication, and they were roadmaps. So RFEs are, if written well by the officer, a great way to get your application approved, which is the bottom line, right? You don't care if they approve all 10 of your criteria or just 3, right? You probably do care because you're proud of your work, but you care for about 2 seconds, because after that you got your next step, and then you can move on. So I think RFEs, if written well, can be really good, really helpful.
Okay, this goes back to the same saying that the burden of proof is always on the petitioner. So it's our job, it's your job to prove to the officer that you actually qualify. The next question: in the event of a denial, what are the odds of a successful appeal? This is a very common question across board.
Yeah,
that we have seen so far. Should someone apply or just file again?
This another really good question. So this helps me feel even more strongly that the people here asking these questions are smart and engaged. And obviously you wouldn't be on this call if it wasn't something you're interested in.
Oh, yes.
So great question. I think that two things. The success rate of appeals is pretty low historically. But one can tell a lot from the denials that you get. There are some instances where, it is my it was my burden, and I guess I didn't succeed in doing it. There are some instances where officers are seeing a case and they're just never going to approve it for whatever reason. That officer does not buy what the petition is selling. And you can tell that through the RFE or the notice of intent to deny and the denial. Like, no matter how qualified it is, nothing's good enough. Should you appeal that? Or should you just file again and hope that that officer isn't the officer that gets the next application? And, chances are there's hundreds of officers and thousands of applications. They won't. And then there's some where, the case from your judgment, and you can tell by the denial, is really close. And if you can add some more evidence, some more contemporaneous evidence on appeal, those might be the ones that are successful. But I think a lot of folks who are in this field and take your experience, that filing again is there's no prejudice against filing again. It's in your file, so they'll see it, but they will not adjudicate anything based on anything other than the papers that you sent for the request that you're making at the time. So the denial won't go against you.
Oh, gotcha. That was going to be my follow-up question, that when denied, does filing again, does it trigger any sort of where the officer goes to say, oh, this is why you were denied before, and I'm sort of going to take that information as I'm adjudicating the current case? So, but I think you've answered that question.
I mean, they're humans, so they'll look through the file, and that could, unfortunately, right, the first thing they'll read about you is why you were found not eligible, and then they'll look at the new filing. So they might have that in their brain. But, denials like RFEs are also a roadmap for how you need to improve. So if you do get denied and you get denied on, A, B, and C, that's what you work on for the next filing. And so they might say, that filing that you did was really insufficient, but this new one has, more exhibits and more proof that you make it. That's a map for the person helping you with your filing.
Gotcha. Next question. Is there, and this is I think it's a very straightforward, is there a pathway for for nurses in other countries looking to relocate to and work in the US?
Yeah, great question. I think I'll talk less about this one than I did on all the other ones. But I mean, there are nurses that come via the EB3 program. Yes. There are nurses that come through the H-1B program. And there are, they're not necessarily legal pathways dedicated solely for nurses, but there are industries that work with nurses in particular countries, in particular places, to make sure they have the right certifications, they pass the right exams, and then they will match them up. So there certainly are services to do that. There's Schedule A, so there's some of the recruiting and other things are less of a burden for people who qualify. So yes, that's something you can look into.
Yeah. So next question for EB1A, what's the difference between? This question. What's the difference between major awards and lesser awards? When is a lesser award way too less? And this question a lot. People say, "Oh, I want an award in my country, and I don't know if it's good enough." Right? So, what?
Now, great question. I mean, the major awards are the ones that you can name off the top of your head. You know them if you see them, right? We always say the Nobel Prize or something like that. Lesser award, I always felt, was a funny way of describing them, because maybe it should be called medium or like non-major, but they're still significant awards, right? They're national awards. They are prestigious awards. They're hard to get. So if I would win an award, best immigration consultant in the United States, but not in the world, I would feel like that was a pretty good award, right? And I wouldn't call it lesser, but that's the kind of the difference between major and lesser that I've always seen is, the major ones get you through the door without really any questions. Your petition will be approved. Lesser are part of meeting your criteria, but they are still significant awards, and you're still going to show that they're, like I said, they're sort of national at least awards. So, best person in America, best person in Nigeria in this category. You'll have to show that here's how the award was run. Here's the judging criteria, and the fact that you've won it is a pretty significant thing. I think once you get below the national level, then you're going to have to work really hard to show that it's prestigious, right? And obviously, if you're in a big and populous nation, that gets easier. If you're in a small locality, it doesn't have to be nation, but if you're, if I win the smartest person in Maryland, that's less impressive and probably not going to do it than if I won the smartest person in, in technology in the eastern seaboard of the United States, because you can say that's 150 million people. So there is some room for context there, but generally the bright line that we've always taught our team about is sort of if it's a national award, if you can demonstrate that's exclusive, then that meets the bar. Below that, you're going to have to work harder. And if it's too small, or if it's company based or something like that, it's probably, as this question says, too less.
Gotcha. So company-based award, too less. We've seen a lot of people say, "Oh, I want the best employee, and I work in this big company."
Yeah, I mean, I have seen people win like best. What was it? Anyway, best whatever you make in a company like Amazon, right? So if you like you're the smartest person in the biggest company, maybe that really helps. Yeah,
gotcha.
It gets hard. Even that was difficult.
Now, next question. There's been a lot of confusing information about the EB2 NIW visa pathways. What are you seeing? Any advice for those who intend to pursue this route? And I'm guessing this person is asking questions around like the increased denial rates.
Yeah.
And like the level of scrutiny that is happening within the adjudication of this class.
Yeah, another awesome question. The history of this, right? About a year ago, USCIS released some new policy on national interest waiver that adjusted a lot of the criteria that you all need to submit to make your case, and seemed to make it a lot broader, right? You can take some more credit from working as part of a team than you had before, for example. Yeah. And then the elections happened, and then the new administration came in. And throughout the springtime and the summer, right, the approval rates went down. There were a lot of requests for evidence.
Yeah.
Another thing that happened, though, after October and even before October, certain countries' proportion of NIW applications went through the roof, right? So
maybe Nigeria.
I won't say Nigeria. I'll keep it out of the continent entirely. For example, Brazil, for example. Yeah. Skyrocketed.
Wow.
And so what I believe is the case with the falling approval rates is some of those applications are now making their way through, and they probably weren't eligible through the old NIW criteria, or maybe even the new NIW criteria. And then secondarily, and we can guess which of these two, were they eligible in the first place, or secondarily, did the new government, the Trump administration, sort of go back on the policy that was issued in October to make some of the criteria simpler and easier to meet? So I think both of those things happened. I don't know which is the most impactful. I mean, the news is that the approval rates, depending on where you look at, if you look at some data, they say 2 out of 3 are still approved, whereas before it was maybe 4 out of 5, 5 out of 6, or the most worst case data is about half of them are still approved. So it's still a viable path, but it's gotten a lot harder. Yeah. So again, the same advice that I started out with: if you're intending to go down that route, just have a plan, have a story, look at your resume, make sure that it's unimpeachable, that you hit all the criteria, get some help to use the right words to tell your story. Yeah. One thing I didn't say before is, and I know I'm guilty of this, I focus on the details. And so I will show up. Thank goodness I haven't been at a job interview in a while, but I will forget to tell the big picture, and I will be so focused on my accomplishment doing, whatever. And I've seen a lot of that where people will go to town and write pages about, this is probably an example now, but how they worked in cloud computing or now how they work in AI. And it's hyper technical, and expecting the USCIS officer to pick up the the crumbs there and follow the trail to why that's outstanding is really difficult. So, two pieces of advice on this question is just know the criteria. If you can, think about how you meet the older criteria, because that's likely what the administration, they have announced they're going to change the rules in this area. They haven't said what they're going to do, but I would assume they're going to go back to the old ways and make it a little more strict. So know the criteria and be sure that you're telling a story about how you knock that criteria out the park.
Gotcha. Thank you for that. We're halfway through our time, but we still got some more questions. So this is too good. So next question. If an EB1A applicant gets approved to pursue an endeavor in the United States, can they change their field of endeavor upon arrival? Are there future negative implications? So yeah. The question is as it is.
Yeah, that's a great question, and it has less to do with EB1A because it's the same for any of the EB categories or any reason for getting your green card, right? So the officer who's deciding your case, aside from all the qualifications and the final merits determination, has to believe that you're coming to the United States to continue in that endeavor, and you have to show your intention to continue in that endeavor. And in a typical case, that's easy to do because you're employed by some corporation and you're in the midst of it, or you're funded and you've got a company that's building this thing or has already built it, and now you're iterating it or taking it to market in a different way, and that's your career, and you show that. The answer to your question, though, is really if you show that intention and you're, never encourage anyone to show up with anything other than the truth, and that is your intention. If the next day you get your green card, you settle into your house in, Las Vegas or wherever you move, and you go down to the casino and you win $400 million because you had some, you can quit that day and you can retire. So if you have the intention coming in, if they approve you, they believe your intention, but circumstances change upon arrival, absolutely. That won't have negative implications. You'll be able to petition for your relatives and take all the other future immigration steps that you need to. With a big star to that answer, unless the Immigration Service thinks that you were lying all along. But that's, unless they can prove it, unless you really were, then that's not going to harm you. You'll be able to take care of business.
Gotcha. To further answer that, further on that question. So if someone comes in and this is a typical case in point, an entrepreneur came in the O1, continue in the industry, then move to the EB1, eventually his business failed and probably go get a 9-to-5 job, but still in the industry, or even started another company different from the plan that I was going to use. So a couple of years down the line, he's about to file for his citizenship, the N400. There's not going to be any level of punitive measures.
No, absolutely not. Yep.
Gotcha.
The only, so at the N400 stage, at the citizenship stage, they will look to make sure that you're getting your green card was lawful. Okay. But as long as there's nothing to show that there's actual lying or actual fraud, right? You won't be questioned about a change in career or a change in job. That's part of the rules, right? The plan is to come and to do the thing that you're good at. If circumstances change, you're admitted into the United States for permanent residence, and you have unfettered access to the labor market, so you can do what you want.
Gotcha. Okay. Thanks very much. That's super helpful. Yeah. Time seems to be flying. Jeez, we have just 20 minutes left. For individuals who qualify for the EB1 visa, who would continue leading projects outside the US after approval, and I think this is what this person is saying.
Yeah.
And I hold the green card while spending significant time abroad to continue global work. 2, my work involves leading research and healthcare delivery programs in Nigeria while collaborating with academic institutions in the United States.
Yeah. Great question, and that sounds like great work. So thanks for doing what you're doing. Yeah, absolutely. That's, I think the government, the USCIS knows that a lot of really important work happens in the way that you describe, where there are different parts in different places, and the geography and the jurisdiction and all that can be varied. The criteria, or the legal requirements, I guess is the right word, is it gets harder to re-enter the country as a permanent resident if you are outside more than 180 days in a row, right?
Yeah.
So you just need to do some planning to make sure that you return to the U.S. every little bit less than 6 months or more. And then if and when, as we talked about in last question, it's time for naturalization, you will need to show that you're in the United States more than not for well, I guess in this case, we're talking about employment based, more than not for the prior 5 years. So it just takes planning. So you can absolutely do what you want to do, but you want to talk to, want to be familiar with the rules. So talk to a lawyer or someone who knows the rules, and just plan accordingly so that you don't ever get accused of abandoning your status or anything like that. And it's manageable. Like I said, if you make plans to return to the U.S. every 6 months or a little bit less than every 6 months, that's the baseline.
Okay. I'll go to the next question. And we've got just 90 minutes left. What exactly is the definition of special talents? I've been building products all my life. I've led efforts to build 2 core banking applications for a bank and a fintech startup in the last 7 years. Is my experience enough, or do I need to bring more to the table? Okay. I think I'll let Michael answer that briefly, but to also just tell this person, you may want to go to the USCIS website for now and go check what that, like, the USCIS has a brief definition of how extraordinary talent is measured. So do all of that, and you can also set up a call with Agora after this to have like a one-on-one conversation around this. But Michael is going to give a top line response to it.
No, and I think that's the answer, right? The answer I was going to give is it depends on your accomplishments.
Yep.
That's where I start, right? I'm not smart enough to know what a core banking application is. I can guess, I guess. But you have to, tell your story honestly and see how it stacks up to the requirements. Yeah. And it could be that you knocked it out of the park, or it could be that you're not close yet. But you really have to sort of honestly look at the accomplishments that are the result of your work. How much of it is your work? How much of it is you being part of something, or, and take a hard look at that. Think about how someone who's skeptical might look at it. Take a look as Yemi said about the, what it says the requirements are for the particular visa or green card that you're looking for, and then see how you stack up. And there's plenty of ways to do that. Yeah.
Next question. In your experience, what's the best route for founders who don't yet qualify for the O1 and EB1, but still want to start the relocation process legally and strategically? How does USCIS assess startup founders from emerging markets like Africa, who might not yet have massive revenue traction, but are building high potential companies?
Yeah, I think the last part is so key, right? So I say this now 13 times, so maybe it doesn't mean anything, but another good question. I think this is emerging markets are a great opportunity because of the fact that maybe you'll describe it differently, but India and China and elsewhere, there is intense competition to show that what they're doing is special there, because there's so much. In emerging markets, you all are not the first on the scene. There have been people immigrating from everywhere for a long time, but you have an opportunity because that level of competition isn't there yet. Yeah. Certainly massive revenue is a great indicator of success and accomplishment, but there are many, many other ways to show that, who's investing in you, who's using your products, how many people are using your products, how many countries, companies, or other organizations have adopted your products. So I think in my experience, there's just a lot less from emerging markets like Africa And that tells me there's a lot more opportunity to
Yep.
show the impact, to show the things. A country like Nigeria is so big in terms of population. If you can show that a significant portion of the population is benefiting from your work, I mean, that's massive, right?
Yep. Yep.
And bringing that to the US to have a similar effect is a pretty compelling argument.
Yeah. Just to add to that, what we've seen is, and Michael can just say this in among all, right, is that there's a level of localization in how the USCIS look at evidence, right? And case in point, using the salary as an example, where people say, oh, for Nigerian context or for Kenyan context or South African context, I earn way above the average person. But if you put me beside somebody who's working in my space in the United States, I don't earn enough. And what we've seen is, and what the law says is, you're measured based on salary among your peers.
Yep.
In your geographical location. So sometimes coming from emerging markets may necessarily not be working against you. That really could be your opportunity. Michael, anything to say to that?
Absolutely. I mean, I think that's another place where there's an opportunity, right? Because you could work, let's say you're filing for something that needs a sponsor, and you could work with your employer to make sure that your salary is in that 95% level. It's something that they can invest in, probably in the scheme of their organization, doable. And if you have a great relationship with your employers, then that's a win-win for everyone. So again, going back to maybe where I started, having a plan, using the resources available, I think that emerging markets are a great opportunity right now. I think I won't say it's easier, but there's a lot more competition in places that, like I said, the India and the China markets that are just have been around longer in the O and the EB1 and other spaces.
Gotcha. Next question, and I think that we'll this is like the second to the last question, and then we'll take questions from the audience.
Yeah, great.
I've seen a couple of hands up. I have Udeze Chidera up, so I'm going to accept you once we run through the questions. How consistent will U.S. immigration policies continue to be based off recent trends?
It was so polite, recent trends.
I guess this person was trying to be polite, where that makes sense.
No, so look, I mean, it is clear that the Trump administration, I think I said this at the start, has taken a hard look at all parts of the pathways that we've been talking about today. With, I'll not attribute any other motives than the ones they use, so I'll be as polite as that. They have this strong narrative that they're doing this to give priority in the American job market to American workers. I will now. Here's where I'll get editorial a little bit. Like on the H-1B front, there are maybe 600,000 H-1Bs in the United States, and technology workers alone, and H-1Bs can be nurses and other things. There are 16 million. So they're really talking about 4 or 5% of the marketplace, really small. So that's my politics, I guess. I don't necessarily believe some of their reasoning, but no matter what, I think, because I don't set the policy, they are, recent trends, like the question suggests, are tightening things, making things harder, telling of their intention to do that in other parts of the immigration world. And so I believe they will continue to do that. It's their intent to do that for the next 3 years. One lesson from the first Trump administration, and we'll see how much this repeats, is that if you look at something like RFE rates as an indicator of changes in rules that made things harder, that made people's applications not be eligible on first route, on first blush, in the first Trump administration, if I can paint a chart for you, the request for evidence rate, and you pick your application on H-1Bs or on EB-1As or on Os, was really high in the first year of the Trump administration, a little less in the second year of the Trump administration, a lot less in the third year. And by the time the first Trump administration ended, it was just about where it started. And what that was the result of was litigation. So immigration lawyers, companies, and everyone sued and said that the changes they were doing weren't lawful, or they didn't make the changes lawfully, which maybe is a fine distinction, or even as silly as a reason, super effective though, that the person who signed the memo wasn't authorized to sign it, because in the first Trump administration, they didn't go through the Senate to confirm their leaders. They just appointed them. Anyway, so what we could see based on that history is that these first few years of the Trump administration, things will be, denial rates will go up, approval rates will go down, there'll be more RFEs, the rules will get harder. Some of them, maybe not all of them this time, who knows how successful they'll be, will get undone in the courts. So going back to the very first question, a viable strategy could be, let's take the next 2 years, take the next 3 years, 36 months to build your resume and see where you are.
Your profile. If you're ready, file. If you're not ready, just focus on building your resume.
Yeah,
I'm going to back off.
And the landscape might be very different.
Yeah. And I totally agree with that. There's currently multiple lawsuits on the H-1B $100,000 increase. We're going to hear what the courts have to say in a couple of months, but I do know of about 3 different class lawsuits against the USCIS and the Trump administration in that space. Next question, which is the last that we'll take from these slides, and then we'll take some of the questions from the chats and have someone and we got another answer. Why does having an immigrant visa approved petition or having an ongoing petition lead to getting denied a visitor visa? Non-immigrant visa.
Yeah, that's a tough one, and it really matters in this case which kind of is it a H or an L or an O or some other petition, and then the immigrant petition. But the answer is that the U.S. immigration law has something called intention, right? And if you are an intending immigrant, that's the word that's in the law, I believe. Yeah. You're going to have a really hard time getting a visitor or other non-immigrant visa, because in order to get that, right, for those of you who've been to the consular interview, the key thing that you have to prove, you have to demonstrate to that consular officer, is that you intend to return once your visit is over, right? You're going to Disney World, or you're going to a business meeting, or you're going to school, university. You have to show to that consular officer that when that is complete, you have financial ties or family ties or other reasons why you're going to come back to your country. If you file for an immigrant visa, that's like your declaration of that you want to stay in the United States permanently. So immigration law just makes that really hard. There are some ways of getting around that. If you have certain non-immigrant visas, then the intent part is less of a hurdle. But again, that's probably too much in the weeds, and you should talk to someone and figure out what your options are before you go down any of those paths, because you don't want to cut off something that you want to do by the choices you make. So just have a plan. Again, have a plan. Talk to someone if you need to, and then proceed knowingly instead of learning about this intent thing after it's too late.
Okay. We're seeing the polls. People are polling with 85% of the people believe this is super helpful. 16% of the people on the call believe that's somewhat. Okay. So this is good. We got live polls ongoing. So we got someone's hands up. Udeze Chidera. So I'm going to accept. I can't accept. Okay, we'll take. So if you got questions, please drop it in the Q&A section and the chat. And I think we already got some questions in that place. This person is very specific. He said, "I'm a founder of a translation company in Kenya. So are there opportunities in translation sector stroke interpretation? If yes, how can I start? I'm interested in exploring translation market in the United States and working with clients in the United States, something around that." Okay, this is a very specific question, and this is from Sharif Ambani. Hi, Sharif. We will share a link after this call. You may be able to have personalized response and conversations around your vision and you will be able to speak to an immigration expert on the Agora side, who can sort of look at your case, look at your business, look at your profile, look at where you're coming from, look at your plan for the US, and be able to share some level of roadmap that you have roadmap with you. But Michael, do you have anything to say to add to that?
Yeah, I mean, I was going to say, I think more generally, it depends what your goals are. Your goals seem to be just based in your question about clients. So, immigration is one thing, and then moving your business to get that market is a separate thing. If it's immigration, certainly, right? You just have to show that the work that you've done in whatever sector you are in this interpretation, I can't imagine there's so much right now that is possible and getting even better all the time, and show that the work that you're doing is sufficient enough to get the immigration category that you want. Certainly there's like so many markets, but certainly in translation with everything that's available, I imagine you can envision what those accomplishments could be.
Okay, we've got just 4 more minutes to go, and I think that we've answered most questions. Udeze, I'm unable to accept you, but if while we're still here before we leave, if you could drop your questions in the chat. Okay, I got another question from Paul. How can one prove the value of earned media mentions as part of EB1 petition? Also, how many scholarly articles are ideal for a professional, including co-written ones? This is very specific. Michael?
I was trying to read the question. Is it on the question?
Yeah, so this person posted it in the chat section.
Oh, in the chat. Awesome.
Yeah, in the
right. Oh, there it is. Yep. How can one prove the value of earned media mentions as part? Oh, okay. And then how many, including co-written ones? Well, yeah, good news on the co-written ones. They're not, they're as valid as anything that you wrote yourself. The number is really, maybe answering your questions in reverse order. The number is really less important than the notoriety, right? So if you can show that you've written just a few articles, but they're in the most important journals or the most important periodicals in the field that you're aiming for, they will go a long way. So I would say it's both quantity and quality. The other thing is there are so many journals out there. There's a lot of work that you and your people that you're working with will have to do to demonstrate that these journals are the ones in their field, to talk about the rules that they have for selecting which articles they publish and all of that. So, more is usually better, but only if you can demonstrate that the quality of the journal and the exclusiveness of the journal is high. And then earned media mentions, that's a great one to show a claim, to show that others are taking advantage of your work. My mind is missing the word, but your individual contribution to the field is demonstrated by people referring to Valverde. His what was I looking at the other day? Someone published a chapter in a book, and they not only showed how many times that book was bought and used, but other ways, other like industry reports about how the methods in that chapter were used by other companies and other organizations. So, similarly with media mentions, that proves your original contribution, especially if you're named by it. So they're super helpful to that.
Okay. There's another question from Temitokwe. It says, does publication by publication houses about what I am building count towards EB1?
It depends, which is never a great answer. The USCIS is skeptical about the easier it is to get those publications if you have to pay for those publications, counts less, right? So it goes back to what I said a minute ago about the exclusiveness, right? They will not only want to know that you're published, but they will want to know that the place that publishes your work. They want to know how the place that publishes your work chooses the people that they publish, right? And so if it's pay to play, then that's not going to work for you very much. If it's really hard to get published in the journal or the way that you do, then that's going to work for you better.
Gotcha. Awesome. We are on the 10 a.m. dead. We're 1 hour in, and we've been able to answer all questions. So we got a question from Oluwatosin Afolabi. We will quickly answer this before we go. This person said, can published reprints on ResearchGate or active work? I think this is similar to the way Michael has answered the question already. It's not just about where it is done; it is about the quality, the number of people that have looked at it, the number of citations. Most importantly, don't just focus on where or how many, but like the quality of usage or citations or mentions or the number of traffic and people that have been to those publications or that read those publications on a monthly or annually basis. And so we may not be able to answer everyone's questions because I still see a couple of hands up, but we're already 1 minute into above the timeline that we're meant to stop this. Someone said this has been very, very helpful. Thanks a lot for setting this up. Oh yeah, thank you for joining. So I recently got so we're already in. Please, we've seen the QR code on the call. Scan it if you would like to have a one-on-one session with someone on our team. I think there's nothing like having a one-on-one session with someone who can sort of look at your situation and look at your profile and give you a tailored advice. So Michael has given us what is going on the other side, which we cannot know. And now we have some very strong idea of how to navigate through this process. One of our biggest beliefs in Agora is that an informed client is simply the best form of client when it comes to immigration. So we're not the kind of immigration firm that sort of feels like, we got to hide the information from people, and that's the only way they will come to us. We believe that the more informed people are, the better it is to work with them, especially when it comes to making decisions and getting them to do the right thing within the provisions of the law. So we will continue to do a lot of these sessions under the Building Beyond Border programs that we have. You will see more of these in coming weeks, in coming months, as we bring more information to everyone. We believe this will get larger. And again, see you guys next month when we do this. And Michael, thank you so much for doing this. We really, really appreciate this. Fun fact, I live in the same state with Michael, and we're like a couple of minutes away from each other. So it's been super helpful in terms of like helping talents from emerging market figure out this what we do here. We all believe that immigration is a great thing. Talents should be able to move. Great talents should be able to move places and build stuff. And it's always beneficial for not just the country, but also the talents themselves. And everybody gets to win when it comes to like global talent migration. So thank you, Michael, and thanks guys for joining. We will send you links and further information and one personalized questions, like I said, answered, like I said. Scan the QR code and talk to us. Thanks, Michael, and enjoy the rest of the
Thanks for having me.
Yeah.
Been fun.
All right. Bye, guys. Okay.